really a very important part of our annual Fidler program, which is to recognize somebody who was dear to many of us in the room and has made a mark forever on the criminal justice system. Today we offer our annual William J. Landers Lecture on Prosecutorial Ethics, but we're not doing a lecture. We're going to do a roundtable by those people who are most esteemed in our community. I wanted to mention just a few words about Bill Landers. Bill Landers was a 1976 graduate of Loyola Law School and editor-in-chief of our Law Review. He was, as many said, a prosecutor's prosecutor. He was an AUSA. Raise your hand in this room if you worked with Bill. Special counsel to the Assistant Attorney General and Associate White House Counsel. And it's hard for me to believe he's been gone for so long. Bill was a man of unimpeachable integrity. And when he passed away, we decided to honor his memory with this annual program. Usually we would have a single lecturer, but we're lucky enough today to have four of the most distinguished lawyers in Los Angeles. And I've asked them just to do a roundtable on the issue of prosecutorial ethics and in general, from both sides, prosecution and defense, the future of white-collar prosecutions. So these individuals are my dear friend, Dan Broderick, who came down from Sacramento. He is the federal public defender in Sacramento. Now that's wonderful, but he also was an assistant United States attorney in Los Angeles. So we've seen the criminal justice system from both sides, and we're delighted he joined us. With him as well is Janet Levine. Janet Levine is, of course, a graduate of this law school. Can I mention #1 in her class? And today, later, will be honored by the Defense Lawyer of the Year Award from the Fidler program. We also have a dear friend and well-recognized attorney from the U.S. Attorney's Office, Alka Seger. Alka has been prosecuting for over 20 years and running some of the most important units in the U.S. Attorney's Office. And finally, our dear friend, Max Huntsman, who is in the District Attorney's Office doing white-collar crime prosecutions. I looked at his bio in your materials. He said that he went to Yale for law school, and now he teaches at the Yale of the West, Loyola Law School. So we want to welcome all of them. And I'm going to throw out the broad question because I've never known any of them to be shy, but I think I might actually start with Dan, or Janet, Dan, they're pointing at each other, jump in. What are some of the issues that are challenging us now in white-collar prosecutions?
Well, right now, actually, it sounds kind of boring, but what's really changed in white-collar prosecutions is the way in which we're getting our discovery. We're getting it now primarily with massive amounts of computer information. We're either getting it in disks or getting it on hard drives, or bring our own hard drive and copying it. And so what that means, or what it's resulted in, is you will get what Janet I were just talking about called a data dump. You'll get a data dump from the prosecutor if you're a defendant that has terabytes of information, hundreds and hundreds of thousands of pages of documents. And if you work in a very, very large firm or a civil firm, or if you work in a public defender's office, okay, you have the resources to be able to go through most of that stuff. It takes a long time. If you're a sole practitioner, if you're a panel attorney, kind of tough. And for judges who like to view themselves as the controllers or the guardians of the federal fisc, they generally don't like to authorize unlimited amounts of money to check out discovery. So that's going to be, I think, the biggest problem right now is trying to see how we're going to deal with that, because it is not right, although it is technically legal, for prosecutors to just bury Brady evidence, exculpatory evidence, in 500,000 pages of documents in the hope that the other side doesn't see it.
So let me ask Alka and Max, are you burying your Brady information,
Yes.
Even though-
We do. We pick out the stuff that proves the person's innocent, and then we hide it inside the $500,000 page. It works great every time.
No, but what challenges are there for your side to deal with discovery?
Well, we're dealing with the same problem. I mean, we're dealing with cases in which the volume of information available is just, massive, doesn't even begin to describe it. We have cases, routine white-collar cases have hundreds of thousands of documents, sometimes, easily exceeding over 1 million pages. And so gone are the days where, all of your evidence would fit in banker's boxes, which you could line up, along one wall of your office or in the hallway outside. Now we're managing all of this information in concordance or other databases, and we're searching for the records ourselves using, the electronic media. And it poses a challenge for us because we need to produce it, no question there. But the other challenge is because there's so much of it and you can't possibly humanly, physically, or even electronically go through every piece of paper, we're finding ourselves in situations where you can't possibly get your arms around a case. So you can't possibly, say that you have turned over every piece of favorable evidence because you haven't gone through every document. And so the only way to comply with our discovery obligations is to turn it all over. And
so that's two problems here. That's right. I've tried 2 cases this year, which I don't often do. One had 3 terabytes of documents, one had 4 terabytes of documents. And to put it in context, I was reading this to Dan earlier, to a terabyte, and this is just a footnote from one of the motions we did. The government has produced or promised to produce about 3 terabytes of data. This data is the equivalent of about 3,000 copies of the Encyclopedia Britannica, or about 30% of the Library of Congress's printed collection. Alternatively, 3 terabytes is approximately 1.5 trillion words. To put that in context, Moby Dick has 211,735 words. In essence, the government has provided the defendant with approximately 7,254,350 Moby Dicks worth of discovery. The problem is the Brady isn't in the documents that's produced. It's in the witness statements, and it's in the material that the federal government still doesn't even put in witness statements. So if you read the Stevens case, and I take that as the mark, the problem wasn't the data they turned over. The problem was they didn't turn over the witness statements. The state government tapes. They go in to talk to a witness. They're going to do a tape of an interview, and you're going to get that tape, good or bad. The federal FBI agents go in with a pencil and a piece of paper, and they write down what they want to write down. And the federal government takes the position, they did in Stevens, that those statements were not producible as witness statements. Well, that's a problem, and that's where the Brady information, the exculpatory information, lies. And the other problem is the federal government reads its obligations under Brady, and Brady is 49 years old now. They read its obligations under Brady, and Brady reads in a very limited sense. The DA's office reads it much more broadly. They don't require the materiality issue. The federal government does. If you look at the bill proposed by Senator Murkowski in the wake of Stevens, materiality gone. It'll make all the difference, and you can't put a materiality provision in with all of this data because the government will never know what's material. They can't even tell from their witness statements because they don't know what the documents say. And there's no other way to figure it out but to turn everything over.
Well, Alka, let me ask, has there been a shift in any discovery policies since big cases in the news, since the Ted Stevens case and the like?
well, I think that, notwithstanding the fact that the Stevens case has garnered a lot of publicity and maybe, I think, unfairly put out the impression out there that, discovery violations are widespread and commonplace among prosecutors, I think, the very vast majority of prosecutors, virtually all prosecutors, take their obligations to produce discovery very seriously, and they work very hard to comply with the laws. And, different states, different districts have different, they approach their obligations to turn over witness statements. There's just different practices in different districts. I know that in some U.S. attorney offices, it's not uncommon for witness statements to be turned over on the day of trial or just before trial. In the Central District, we turn over those witness statements, along with the rest of our documents. So it's different practices. Whether there has been a shift, I can't say that there has been right now, but I do want to underscore the point that this is not, notwithstanding Stevens, this is not a practice that is widespread or common by any means.
And Max, I know you work on some of the biggest cases with the most documents and computer documents. In fact, sometimes you have the help of special masters, right?
I have occasionally had the help of one particular special master.
Yeah, how was she?
She was wonderful.
Yeah, okay, good. But the real question is, these computer documents, do you and your investigators actually ever get through all of these? Are you looking for the needle in the haystack, or are you using a cooperating insider to help guide you, and does that pose problems?
We cheat. We use keyword searches. We look for stuff. The way I have always approached white-collar cases is to look for the piece of evidence that's going to show me what happened rather than trying to digest 3 terabytes of data. And in our modern world, that becomes much more important because it's impossible to digest everything that's out there. So yes, if you have somebody on the inside who can point you, that's good. If you can find a piece of evidence that decisively proves a point, rather than exist in some sort of morass where it's unclear what happened, then you're in great shape. You only then have the problem of discovery issues, which I think both Janet and Alka addressed, that are inherent in our modern world of technology, which is, here's a vast amount of data. What do you do with that? Well, yes, we have to give it to the defense. What we always do is we go hunting, using whatever tools we have. We find what we find what we think is important, and we give it all to the defense. And we then also give them the 3 terabytes of data so they can do their own hunt if they want. And we look at the 3 terabytes of data as like the field out there where the gun might be hidden somewhere. It's not our duty to go hunt in the field. They want to go hunt in the field, they can, but we give them everything we find. We don't hide it within that other data. We have a different set of rules and laws, and it's not all entirely because of our goodness of our heart compared to the federal system operates under a different set of rules. But we're fortunate that we don't have exactly the same problems with Brady.
So Dan, the image of white-collar cases is that you have defendants who are represented by major law firms and they have unlimited resources to start hunting or to defend these cases. Is that true? I mean, what are you seeing in your office?
Well, actually, we have the highest number of mortgage fraud cases in the United States of America in our district, and in fact, the highest number of mortgage fraud cases in our office than I suspect we have more mortgage fraud cases in our office than the entire number of lawyers in this room right now. So it's really not exactly true. Now, that it is true that our U.S. Attorney's Office tends to go after low-hanging fruit more often than
and they're not represented here.
Other offices do. Here they tend to go a little bit higher up the food chain, which I think politically is an appropriate thing to do. So we get a lot of straw buyers, we get a lot of mortgage brokers, we get people like that who are not very good at what they do, and so that's how they get us, because they don't make much money. So we have an awful lot of them. And when you're talking about stuff like, to follow up on Janet's point, one of the things, it's a perception, I think, when you're talking about Brady. And it's that perception in the prosecutors' minds and law enforcement minds that needs to change. For example, in our mortgage fraud areas, Brady applies obviously both to guilt and sentencing. So more often than not, they have, yes, I lived there and they didn't get to live there, so you're going to have a false statement. So you're going to have, the guilt is generally not going to be a huge, big issue. Sentencing, on the other hand, is a major issue in mortgage fraud cases. And what happens is when the banks and lenders shifted to a MERS system, which they did, to hide the transfers of property from public view, okay, the U.S. Attorney's Office don't care, and they don't look. Whereas we say, wait, when this named victim sold the mortgage to another bank subsidiary, they knew at that point. So that's where the loss stops. It isn't when they finally sell the house, okay, which is what the ridiculous sentencing commission tries to say. But the U.S. attorneys uniformly, maybe not in this district, uniformly, that's not my problem. That's not my issue. I don't have to look at MERS, okay? So it's really a perception of, yes, it is. Yes, it is. You have the ability to get that. We don't, okay? So get it and give it to us.
Alka, if a defense lawyer asks you to get something, do you go and help them get it, or you say, you go get it?
Well, it depends on what it is. I mean, if it's something that, you know, they are able to, if public information that they can get just as easily as we can, I don't think we're under any obligation to get it for them. But, you know, we do want to find, you know, everything out that's relevant to the case. And if the defense attorney calls me up and says, we need this, they don't have the ability to get it, you know, I'll get it, because if it's important to them, it's going to be important to me. And it's going to be important to me to know what's important to them.
Janet, sometimes prosecutors get themselves in trouble where they might have won a case, but these little sticking points early on hurt them. You recently were successful in your last 2 cases. What were the Achilles heels of the prosecution cases?
Well, the last case I did was it was a hung jury, and it had nothing to do with anything. I mean, there were no discovery issues or anything else. It really was, though, finding the needle in the haystack. I mean, our case was built on some documents that we found in the 4 terabytes by going through the documents, basically page by page, to find the key documents that we needed, which I think is one of the...
How many associates were working on that?
Well, there were a lot of people, and I think that's one of the problems. It's not... You know, what's odd is we're talking Brady, which is 63, and, you know, the other case that was 63 is Gideon. And the problem, right to counsel, the problem you have isn't in my office, and it's not in Dan's office. It's when you have a defendant with $50,000 for a lawyer, and he doesn't get one appointed, and somebody has to go through 100 million emails or something along, not 100 million, but millions of emails, or has an appointed lawyer who works alone. How are you going to have effective counsel in this world with our rules the way they are, with documents? And it's not the prosecution's fault. They don't generally have any more tools to find out, when you're talking about materiality, what's material to the defense. But our system doesn't work with this many documents in this type of form anymore. And we have to do things. I think you were talking this morning, or some panel this morning was talking about Jones and looking at the Fourth Amendment in different ways as technology changes. We have to look at evidence and the roles of lawyers and the roles of our adversary system a little more creatively.
So Max, when you work with defense counsel on these cases to get them the information, is there a conference ahead of time? Do you meet and confer and decide what you want to do? Or is it all done by bothering the judges with motions?
No, usually we have a lot of, on a white collar case, we have a lot of contact with defense counsel. Not always, it depends on the case, but we tend to talk to them before we file. We tend to put all our cards face up on the table. You know, I'm sort of naive. I like to think that I put all my cards up on the table. The defense counsel will go, oh my gosh, you got me. And, you know, we'll get a plea early on and we'll go on to sentencing. It doesn't usually work that way. We end up having to have a trial. You know, and we convict a guy, gets double the time. But, you know, that's kind of the way we play the game. And I think we don't have a lot of contested discovery motions. But it doesn't erase this issue that we're talking about here, which is, in a world of information glut, what do you do about that? And that's a real problem.
And what should the judges do about it? We have judges here. I mean, you run to the judge and say, we've got a problem. Either we've had everything dumped on us or we haven't had enough dumped on us. I'm not sure what the court's supposed to do.
I think the judges are, in a way, without rules that govern it, the least equipped to deal with this problem. I mean, you've got a judge in state court, they don't have clerks. They don't have the ability to get through that. And in federal court, there are no rules. We have a protocol now, but there are no rules to deal with this massive e-discovery and no facility to do it. I tried a case against Max, and the key to not having discovery disputes was communication. I mean, the system needs to build into it what the federal system doesn't have, a forced discussion somewhere along the way.
And that leads me to a sort of a separate area here, which is we often hear the need for civility, right, in prosecution cases. I'm wondering what the level of rancor is, and I know it may depend on where you are in the districts, but do we have a level of civility in the prosecution of white-collar cases? And Dan, your smile couldn't be bigger.
No, I actually think that the number of, I'll be polite and say ethically challenged prosecutors that I've faced is very small. There's certainly a subset of a larger group. I don't think, there are some who intentionally keep Brady and keep exculpatory evidence away. I mean, everybody who's ever done defense work certainly has examples of that. But I think the most prosecutors are trying to do what they think is the right thing, and it's just that they just don't understand what exculpatory evidence is.
Well, when you mentioned civility, I mean, I think there's a benefit to civility independent of ethics, which is when two people act in a friendly manner and work together in order to accomplish a mutual goal, which is getting through this process. You are much less likely. I mean, Stevens, sure, there was some outrageous behavior there, I believe. But there was a lot that, as you read through it, you're like, gosh, that's not that different than mistakes that people can make when they're overburdened and they have too much and they sort of leave this aside. When you sit down together and work together, you're much less likely to run into either intentional discovery violations or, which I think is a much huger problem in white-collar crime, unintentional discovery violations because of the mass of stuff that's out there that just is sort of not picked up on and becomes an issue. If you work together, you're more likely not to play right next to the edge and have trouble.
Can I ask about publicity? And we used to have a lot of problems with perp walks and the idea that, prosecutors would try to get their time up front and that they would stigmatize, especially white-collar criminals. Have we moved on from that era?
No, we like to do that. That's fun. That's still fun. We want to have a little fun. So we like to arrest people. And in fact, personally, I think it's legitimate. When we talked about prosecutorial ethics and white-collar crime, I represent the people. The people told me they want to see white-collar criminals punished. They want to see them treated like ordinary criminals.
What about the presumption of innocence on the way there?
The car thief gets hooked up and taken down to the station too. And so
As does the drug dealer.
I feel like the white-collar criminal has to be treated that same way. Now, sure, there are exceptions. There are people who aren't flight risks, who are non-issues, which are not that complex a case, which we have a lot of. But in general...
But pretrial detention is for danger, the safety of the community, or flight risk. So you've got, in a white-collar case, generally a lot of communication between... and a lot of knowledge that goes on back and forth. So you don't have a flight risk. You generally don't have danger, which is why in the discovery issues, we're not dealing with hiding things or keeping them out to protect witness safety, national security. When this is a case of money either gone awry or not gone awry. So why, I understand that there are reasons you want to have so-and-so was arrested or you want to have the first press conference, but why do you have to pick them up at 6 a.m. in front of their kids? What is that about?
I don't know that you have to do that. I would much rather pick them up at 4 p.m. in front of the city council, personally, than in front of their kids. But having said that, there's an extra factor at the state level anyway, which is seriousness of the crime. Mm-hmm. And I can't speak for the federal system, but that's a definite factor in bail setting, and when you look into the Superior Court bail schedule, it's why we have substantial bails, quite independent of flight risk and quite independent of danger to the community, although I do believe many white-collar criminals are a danger to the community, just not in the gun-in-your-face sense. But again, I think the people have a right to see their public system working and to see that the most powerful among us are treated like the least powerful. That is not to say that there can't be inappropriate gaming of the system, that there can't be games played like what you're talking about with the kids and blah, blah, blah. I mean, yeah, it can be pushed too hard, it can be done in inappropriate cases, but should we have a flat rule that white-collar criminals get to walk into court and everybody shakes hands and hug each other? I mean, I get my hand shaken by white-collar criminals sometimes. It freaks me out. We're not all buddies, It's not supposed to be fun. So,
alleged white-collar criminals.
Alleged, excuse me.
Right, alleged white-collar
Excuse me.
Just to give you a sense of a different world than you in L.A., last fiscal year in the Eastern District, there were 9 summonses total in the entire district.
Really?
That was it. They arrest everybody. And the U.S. attorneys move for detention in 89% of the times. So
this pretty
it's a different world in other places.
You're in a time of economic trouble and priorities and all of those things, and we're not supposed to use the system to game pleas or anything like that. I mean, you don't want to hold someone in jail, I wouldn't think, to make them plead to something.
No, of course I would not want to do that, but if I wanted to do it, I couldn't, because people get out. Every motion we have to examine source of bail, they get out in a week anyway. It's not a tool that we have, so I'll never know whether or not I would want to use it. But you mentioned the resource issue. I say realignment, and what was talked a little bit about in the panel on realignment, the horrible tragedy that LA was in before realignment, which is the people were doing a tiny fraction of their jail sentences. The guy who murders somebody, he still goes to prison. The white-collar criminals are the people who get out as a result. Judge Marcus was here talking. I'd done a couple trials in his court. One defendant got sentenced to 180 days in county jail because she shouldn't have gone to prison. It would be a waste of resources. She did 4 hours. Another one recently got 60 days. He did 4 days. So the white-collar criminal who ought to be receiving a punishment, and we're talking about cases where they weren't prison, and we got lots that go to prison, they're not getting punished in the way that they should. And that's why I say, I mentioned the people and what prosecutorial ethics is about here. Yes, absolutely, the rights of the defendant are a big deal, and Brady is a big deal, but one of the greatest challenges, I think, in white-collar crime is making sure that our system doesn't slap the wrist of the wealthy and privileged while we grind other people under the boot.
But isn't
the boot's got to grind everybody.
Max, so you've got
or
somebody,
not, whichever.
I mean, if you want to put someone in jail and the sentence is 180 days and you don't have space because you're holding people pretrial that may not get a sentence, I mean, that's your weighing thing. And that's, I mean, if you're looking at what is ethical and what isn't, once you've convicted somebody, it's a very different story. I just think it's not particularly forthright to hold someone in custody for the purpose of extracting something that you might not otherwise be able to get or
Are some of these white-collar criminals, though, flight risks? I mean, we're assuming
absolutely
they're not.
Absolutely they are. I mean, we're seeing, the problem is that your clients don't always tell you everything. And so you don't really have a basis for, when you come into our offices or you call us on the phone and you say, I want my client to be summoned in, or will my client be summoned in? And we say, no, we cannot make any assurance regarding the manner in which we're going to take your client into custody or whether we're going to summon him in. It's because we have information that you don't have. And in this era of social media, we've had cases where people under investigation are sending emails and texts about how they are, ready to fly out at a moment's notice to a country that they have, other identification for, and how they're committing ongoing crimes while we're investigating them. And those are reasons that we take into account in making our determinations as to whether we're going to let somebody come in under a summons or whether we're going to arrest them. And you mentioned something about, putting handcuffs on people in front of children. And I just want to say that in my, 20 plus years working with federal law enforcement agents, I have never come across a situation where the agents designed an arrest so that they could traumatize children and do it in a manner that would be harmful or in front of their family or something. Instead, what I see is operation plans where they go to great lengths to make sure that children have left for school, or they'll tell the person, we're here to take you into custody, please make some phone calls so you can have somebody come and take care of your children. And it's just not the case that they go out there, guns drawn, to slap handcuffs solely for the purpose of getting an advantage in a case. I've never, ever seen that happen. And I've had defense lawyers on many occasions express their appreciation for the professionalism of the agents and the way they've carried out their duties.
And that's
I just want to get the flip side. I did have a client, I know everybody has anecdotal stories, who was arrested at a school assembly and in front of everybody in the school at a PTA thing and handcuffed with guns drawn in front of the entire school. And they were released OR. but it does
That's not
happen.
this district.
It's not this district.
Okay.
It's not this district.
Well, you got half what he wanted.
Certainly, I mean, anecdotally, you know, I'm sitting to the side of Alka. Alka's a great prosecutor, but you can't say just because 99% of people are great that the 1% that make errors, it's okay. And so we're talking about a small slice. But the question is, what rules do we need for the small slice? And we're also talking about big pictures that we can all agree on, that we all have a problem with massive amounts of electronically stored information. And how do we make that work so that people don't slide into a constitutional violation?
One other area I wanted to touch on, because I've heard it, the fingers pointed both ways, is the idea of leaking information about a case that's not out there that may affect the jury pool. Sometimes I hear it's the prosecution, the police that are leaking. Sometimes I hear, no, the defense is leaking. Is this a concern? Is this something that you see happening?
Not for us. We don't control, our spigot just is open all the time, so we don't have to go out and get business. It comes to us. And so I don't think I've done a press release in the whole time I've been in this office, so it's not something we do. The prosecutors do press releases, and trust me, we keep control of them when they release them, so that if later on we needed a trial, we can say this is an admission of a party opponent's agent saying this is what it was all about, ladies, gentlemen, and it's not true. And they do it for whatever reason they want to do it, for deterrence purposes or whatever. I think it's overused, and I understand it's a political job for people, and that doesn't make it fine in some cases. And I don't mean to make anybody sad, because we also have the highest number of kiddie porn cases, and I got an email today that another one committed suicide when the press release came out. You don't really need to do that. They don't need to do a press release for those purposes.
For the purpose of causing somebody to commit suicide, no. But press releases are appropriate when it comes to doing the public's business on cases that are of appropriate high-profile interest to the public. Depends on the case. In the unit I'm in, most of our cases are stuff that the press has been hounding whomever it is, us and everybody else, about what's happening, what's happening, what's happening. Well, guess what? Something happened. So we're going to tell them about it. We do the public's business in public. You cannot obviously leak information that's going to bias a jury pool, nor would you want to. We use information that's part of the public record. Generally speaking, it's not a lot of detailed information anyway. I have never found it to be a problem with picking a jury pool. When we go to actually pick juries, they don't know anything about our biggest high-profile cases. You know, you start going through the jury, and it's easy to pick somebody who never watches TV, reads the paper, or anything. I mean, no, it's not a problem at all. Doesn't mean that there aren't other collateral issues that it is, but as to jury selection in the LA metropolitan area, not an issue.
Questions or comments by people for our roundtable? Then let me finish up maybe with this area, which is, I'd like you to give one great idea, not good, but one great idea, and how we can resolve any of the tensions we've seen in the area of white-collar prosecutions. And I guess I'm going to start with you, Dan.
I can't say it's a great idea. I think it would be a very good idea if every prosecutor's office, state or federal, had every year somebody from the defense bar come and talk to their attorneys about what Brady is. Hear it from us. Let me come and tell you. Tell us what we do. I'll tell you what we do. It doesn't have to be case specific, but let me talk to your people and say, this is what Brady is to a defense attorney. Maybe it won't work, but at least I'll know you all heard it.
Janet.
I'd get rid of materiality in Brady. Require the production of all evidence that's favorable, that has to go with pretrial motions.
Can I push on that a little bit? Because I just taught Brady to my students, and many of them just asked the question, how are prosecutors supposed to know what you think is favorable? And I hear Dan say maybe we can come and educate you on that. Do you have any other suggestions?
There is no way that a prosecutor can know what's favorable to my case. They can't know what my defense is. That's not possible.
So then you're really saying open file discovery?
No.
Time out. That's just bogus. I hear that from so many prosecutors, Jen, I'm surprised. Prosecutors, certainly not the ones on this table, are not dumb. okay? Prosecutors know, and particularly experienced ones, know what they're doing, okay? When you've done 5 cases, 6 cases, 7 cases, you know pretty much the gamut of what our defenses are going to be. Okay, now you may not know about one thing or where we're going to put our emphasis on, but you darn well know what our defenses are. There aren't that many of them.
But they don't know which witness we have this on, which witness. I'm not saying open discovery, but why not? That's what the DA's office does. What is wrong? And terrorism, danger to a witness, put that aside. You can protect that in the DA's office. In DA's offices throughout this country do not have materiality as a piece of the production of favorable evidence. And the way materiality is read by the U.S. Attorney's Office is in the post-trial appellate view of would it cause the reversal of this conviction. That's absurd because no one's going to know how we're going to use it. In the case that I was talking about, that I was going through all of the evidence to find the pieces of evidence, it was a document my client didn't sign. How would they know that I was looking for a particular document in a particular deal where there was a unsigned
Why don't you
page?
just ask for it? Why don't you say, do you have any documents in this deal that my client didn't sign?
Because you don't have to do it that way.
Because you don't want us to.
You don't have to.
If you're looking for the document.
And I don't know all of what's there, right? You ask the grand jury, you interview the witnesses, you have the badge, people don't talk to us. So put it in a position, and as you say, our clients don't tell us everything. So we're sitting there trying to do a defense, our clients are presumed innocent and entitled to present a defense, and we're not given the tools to do it. So it's easy to say, yeah, let's make it into a civil world where we're both doing depositions, and that's fine. You want to do that, that's fine. But short of that, take the witness statements and turn them over. It's not that hard.
It actually sounds like the problem's not in the documents, but in the witness statements. Alka, you have an idea.
My idea would be that, I've come across a lot of situations where we have a lot of evidence that we are willing to turn over, particularly in these massive identity theft cases that we're doing, but we can't disclose a lot of those records. We have to heavily redact them. That's very time consuming, and then the claim is that they can't really make sense of them because they're so heavily redacted. So what I would like to see is defense lawyers be more willing to take that discovery under terms of protective orders and agreements not to, if they're going to show them to their clients, not to make sure that their clients don't make notes regarding that information.
And Mr. Huntsman?
A couple of years ago, I was on a panel here, and a former U.S. attorney made a joke at the expense of the district attorney's office. He said we were like McDonald's, that there were 99 billion served, but you wouldn't want us to cater your wedding. And I thought that was rude and hurtful. However, there was some truth to it. We serve a lot of burgers. And when you are a county employee and you serve 99 billion burgers, you're broken down. You no longer have individual creativity or will to do something different. You do the same thing every time. That's how we do it. We have rules about how to provide discovery, which is pretty much give them everything, and we do. We don't have any motive to do otherwise, and it works just great. I wouldn't advocate what Janet is saying about removing the materiality standard from Brady, because all you're doing is changing which yard line of the playing field you're on. You're going to still have the same aggressive fighting and cases getting thrown out as a result. What we have here is we have a two-tiered system that works great. You've got Brady. That's the third rail that if you touch it, you get electrocuted. But way before that, we have a whole bunch of discovery obligations. It's not quite open file. Everybody talks like it is. I'll just give them everything. I mean, there is some stuff you sometimes got to redact or stuff that's not relevant. But for the most part, we just give it over for exactly these problems. I don't want to have to try to figure out what little clever things Janet is up to. If she wants to tell me and I can find something for her, great. But if I just give her the stuff, then I don't have to worry about that. And we find that works pretty darn good down here in little simple county employee land.
I want to thank our roundtable panel.